Hey there, thanks for joining me in this phase of our journey where we will be demystifying the Patents Act from the perspective of others. Let's start this phase of our journey by discussing a scenario where a person from the others is making a claim to be an applicant in a patent application. Now you may wonder, under what situations or scenarios such a claim can be made where a person is claiming to be an applicant for a patent application which has already been filed by other applicants. Think of it. During normal course of business, there are mergers, acquisitions, or collaborations, which may result in other person deriving interest in the projects or patent applications related to or relevant to such collaborations. Another scenario could be where a court has passed a judgment in your favor with regards to the rights associated with properties, including patents and applications. In such cases, you may want the patent applications to have you as an applicant. There could be an unfortunate event where one or more applicants, the original applicants, die. In such cases, the application needs to be proceed with the survivors. You could be one of those. Finally, there could be some dispute between the applicants, the original applicants, which may require the application to be processed in only few of the original applicants. So section 20 provides us with the procedures and requirements that are to be met with regards to all such cases that we talked about. Let's go over each case one by one and understand what are the processes and what are the requirements that needs to be met while making such a claim or such a request with the controller. With the first one, as per section 20.1, where the original applicants have assigned their rights in the application to new persons. In such case, the person needs to approach the controller with a request to add their name as the applicant. Could be only their name or jointly with the previous applicants. Now, how do you do that? So as per Rule 34, you are required to use Form 6, provides a detail about you being the applicant, who were the earlier applicant, and on what basis are you making such a request. You need to provide supporting documents, which are the agreement and the assignments that you signed with the original applicant. Upon receiving such a request from the claimant, the controller goes over the request, the form, and the supporting document that have been provided by the claimant before passing a judgment. In fact, the controller may provide an opportunity of hearing to the claimant to understand the case in a better manner. You may appreciate that in all such cases, the decision is largely based on the documents, the supporting documents which have been submitted by the claimant. Therefore, it becomes critical for the controller to ensure that the documents are in good shape and indeed are relevant for the patent application against which such a claim is made. Now, how do you ensure all this? So the Act provides a few checkpoints for the controller to ensure that the documents are in place. For any property, when such an assignment happens, it should be with the consent of all the applicants. So that is one first requirement that needs to be ensured. Second is to ensure that the agreement or the assignment that is submitted is indeed relevant or related to the patent application in question. How do you ensure that? One simple way could be to include the patent application number in the assignment itself. So there is a clear indication that this assignment relates to this particular patent application. Now, what if that is not possible? In such cases, an acknowledgement from the earlier applicant can also work, which states that this particular assignment or deed of assignment is indeed related to the patent application for which the claim is being made. Another way could be, supporting the Form 6 or deed of assignment with an order from a court, which clarifies your stand or your rights with respect to a particular patent application. Finally, when the controller is satisfied with all the documents, all the requirements, and is of the view that the claim is valid, the controller can pass a decision for substitution of applicants. One case could be where the other applicants are removed and the application is only proceed with the new applicant. Another case could be where the names are added along with the old applicants. This was the case when we were talking about change of applicants based on the deed of assignment, which was done between the earlier applicant and the new applicant. Let's go over another case, that unfortunate event where one or more applicant dies before the grant of the patent. In such cases, survivors or anybody on behalf of the survivors can request the controller to substitute the names, basically, to proceed the application on the names of survivors. Now, what all documents that need to be provided? So supporting documents that are required in such cases are death certificate, and also the legal representative of the deceased should provide their consent for such a claim that is made by the survivors. And upon verifying all the documents and all the requirements, the controller will pass an order letting the application to be proceed on the name of the survivors. Let's discuss another scenario where there is a dispute between the applicants in terms of whether the application should be proceed or in what manner the application should proceed. Section 20.5 talks about the processes, requirements for resolving such dispute. So as per Rule 36, one or more applicants can approach the controller requesting his direction for resolving such a dispute. The details that need to be provided are what is the dispute all about and what is the direction that these applicants are seeking from the controller. Upon receiving such a request, controller notifies the other applicant or any other person who are registered as interested parties in the register at the patent office. In order to move forward with such dispute resolution, a hearing can be called by the controller among the parties where both the parties put their request forward, put their arguments forward. Finally, after going through the documents submitted by both the parties and listening to their arguments during the hearing, controller issues a directions with regards to in whose names the application should proceed or in what manner the application should proceed, or both the cases. And accordingly, the substitution of applicant name happens. So we discussed a few cases where a change of applicant or substitution of applicant can happen before the grant of the patent and how such cases are handled. In the next episode, we will discuss a related issue, but with regards to the inventorship. How a person who wishes to be named as inventor for a particular application can approach the controller. So I'll see you in the next video. Till then, be good and take care.